Welcome everyone to day 2 with Professor Ahmad Atif Ahmad from the University of California, Santa Barbara, where he is a professor of religious studies. We are very grateful that he's been spending so much time with us, answering questions both inside these lectures that he's giving and then also very generously outside these lectures as well. Yesterday he focused on classical Islamic law, which is one of his main interests, and today we're going to delve into the modern world, where he's going to give us a comparative analysis of Islamic law in Pakistan, Saudi Arabia, and Egypt. So, welcome.
Thank you very much again for your generosity. I enjoyed the talk yesterday very much. And it was, I think, good that we ended up with a basic point and a reflection on even on the title of the talk. The title was The Crisis of Islamic Law. And we continue to wonder what that means, even though I defined it from the beginning. So is there a crisis, and is a crisis a good thing, even though also we talked about the opportunity that may come from the crisis. Today, I want to be maybe less excitable. If yesterday I was a little excitable. Yesterday actually I took people very far into the past, and we talked about old discussions and very different environments. But today we're grounded in the modern world, and I will try to be as descriptive as I can be, because what I'm talking about today actually comes from a project that I'm trying to finish, which is a textbook. In a textbook, you're not supposed to provide cutting-edge information or new ideas or anything like that. You're trying to summarize the state of the field to the extent that I can. And honestly, I want to tell you, just a side note, when I was contacted by the publisher, it's Bloomsbury in London, and they were asking, well, do we have a textbook that's just an introduction to Islamic law that is good? And the editor told me that she asked 5 or 6 people who came up with the same answer. No, we don't really have the proper textbook, because most of the existing texts are either history of Islamic law or some of these maybe more confessional or holistic approaches to it. It's a bit unfair to say that, because there are good books, and you can assemble, as an instructor, you can assemble material from different books. But it is broadly true. We don't have that panoramic introduction to Islamic law that a junior or a senior in college would need in the American context, or in Australia or Canada, these places. So the second question the publisher asked, or the editor said, well, are you willing to write it? And that question was given to 5 or 6 other people, and they all said no. So yes, it's needed. No, I'm not going to do it. And then I could have provided the same answer. I actually said, I'd like to have a co-author. Can I have a co-author? Can we have somebody who knows a little more about the areas that I don't know enough about? But that was rejected, and at the end, I had to accept to do the research that I needed about the areas that I knew would require some research. But in any case, I could talk about the structure of the textbook later, but what I chose to do today is to answer this basic question: what is Islamic law today like? Regardless of whether it's going a revival, undergoing a crisis, has already woken up from the crisis and is on its way to flourishing. I mean, it doesn't matter how we describe it, but we can still agree on a few things, a few descriptive things. This comes in my textbook. The part of it that's about national law is later in chapter 6 out of 8. But there are aspects also that I want to add to the national law. I know the promise of the talk is that I'll talk about Egypt, Saudi Arabia, and Pakistan, but I want to do a little more. And that is because of what happened last night, that I realized that the way we use Sharia, the word Sharia and the word law, is so diverse, and I have to include this big picture, which I do in the textbook. So we'll talk about Islamic law that's in the national laws, and I will speak about Egypt, Saudi Arabia, and Pakistan, with something of a surprise to me when I started to read more about Pakistan and Saudi Arabia in terms of the similarity between these two countries and Egypt. I know there are always disanalogies and always dissimilarities, but I was surprised by some of the similarities, at least as things turn out in the 21st century, because these 3 systems didn't look like that 100 years ago in terms of the role of Sharia in forming the laws today. But I won't limit myself to national laws. So I want to talk about what I mentioned in the textbook as the personal Sharia, the aspects of Sharia that are personal law, where the national law might not say anything, but people still restrict themselves or sometimes violate the law because they have a sense of where the Sharia takes them. Fatwa case law that could be also globalized, that essentially comes in context today in the cyber jurisprudence world. The community could consist of people who don't share a local context. So the old idea of a fatwa, you need a context. And sometimes when they talk about the requirements of ijtihad, toward the end they say, and then if you're going to work as a mufti or a qadi, you have to know the customs of the town. So you could be the best scholar in Damascus, and you'd be the lousiest mufti in Morocco, because you'll keep misunderstanding the questions, right? You'll keep answering different questions. But this context is evaporating. How are these cyber jurisprudence communities being formed, where people are thinking about the same question as if it is globalized, right? It has one answer that could apply in other contexts. Well, it's happening, so it needs analysis, and it is part of how Islamic law manifests itself today. So it's in the national laws, it's in the personal laws, and it's also in something I call the transnational Sharia. The Islamic finance presence, with all its failures, with all its problems, is about 1% to 2% of the size of the world economy today. And with all its concessions to the classical economic system, it has changed the picture for some people, some individuals, and some communities in the Muslim world and even outside. It has changed the direction of some English lawyers, for example. They have found business in the Muslim world. And it will serve, as I told some of you earlier today, as slots or depositories for new ideas that might come in the future. So whether we get philosophical or, to be honest between me and you, or rhetorical and say Islamic law is dead, because it is by a sleight of hand of rhetoric that we say Islamic law is dead. And I wonder how that would be helpful if you convince somebody in a classroom that Islamic law is dead, and then they go to a court in Indonesia or Pakistan and they're handed down a decision. It's based on a modern interpretation of a medieval legal institution. I mean, it won't help, wouldn't it? Would it? So it's better to be realistic and understand how things are developing, even if we don't like the way they're developing. What are the tools? How can I study Islamic law today? How can I present it to that student? Maybe we'll stick with the textbook as a glue for this conversation. Well, I can do what the historians do, because still Islamic legal history is the dominant perspective and the dominant approach to the subject in the American universities. But that's exactly where the problem lies. Didn't we say that part of why the best books in Islamic legal history are not very good books as introduction to Islamic law? In fact, the historian cannot do this work. The historian, if the subject is Islamic legal reasoning, and that's what I take it to be, that's what I want to teach the students, is to understand Islamic legal reasoning whether you share it again or not. If the subject is reasoning, the historian is totally unqualified to do this. The historian's subject is the totality of the human experience. They're very interested in aberrations. The distinction between a majority and a minority doesn't matter. A rule that applies to human behavior and regularizes it, at least in theory, even though the subject or the individual might elect not to follow the rule, but the existence of the rule is more important in legal reasoning than the exception. The historian doesn't see that. In fact, actually, the more I thought about some of the best minds that practiced their scholarship and offered it to the Anglophone world and wrote the best books that we have in English, I started to remember this little insight that you may have heard in different contexts, and I heard it many times. The best engineers are very bad doctors. Okay? Right? You can't teach Islamic law as history. Can't even do it actually the way Roman law is taught, which is taught in a very limited way in some law schools and some history classes. Because you can check out Roman law textbooks. Roman law is still kind of, in a weird way, it makes appearances. So you could have a Scottish judge, for example, making a case based on an old institution that gets revived or reinterpreted, even though nobody thinks that the Roman Empire is around, right? So, it's the question here is the idea, the law as an idea or as an institution that can be developed. Well, if it is not history, then what? There are other tools, but I don't want to deny, by the way, that history is a very important tool. It's one tool. It can't be the dominant one because, honestly, even our understanding of reasoning can be impaired by the lack of understanding of the context. So, if you want a spectrum, there is a way to destroy the value of history by becoming essentially just a historian of the ideas that are called law. And there is a way to be short on historical material when you don't understand the context behind a certain opinion. You can't do law also based on the headlines, right? You can't just read a fatwa that's 2 lines and you think you understand. Sometimes the context is not stipulated there or is not indicated, and you have to do some historical research to understand that. And some of the bad generalizations that we have and some of the extreme views that we have that attribute themselves to past ideas are innocent of that understanding of the context, right? So we can't deny that history is an important tool, but it can't be the dominant perspective. If we deny history that status of being the dominant perspective, well, what is the dominant perspective? You'll make sociology, for example, be the dominant perspective. Sociology has tremendous tools and can also tell us quite a bit about, in fatwa case law in particular, focus on the context and understand things that are not indicated but are operative, sometimes actually controlling even the mind of the mufti. So the sociology of law is one of the successful fields as it applies to modern law. Why not apply it to the past? Why not apply it to the present in Muslim world? Why not apply it as one of the tools? It's one of the dominant, one of the tools that you can use, right? Within that, there are sub-tools, for example, focus on feminist justice, sexual justice, issues like that, which have been introduced and have become significant in the way people approach Islamic law. Some people are not interested in the Islamic legal system or Islamic legal reasoning, but they know a lot about discrimination against women. They know a lot about the patriarchal approach to law, the fact that Muslim jurists just can't understand women. They don't seem to understand them. And the best thing they can do is to devise a concept for the woman in the marriage contract. What does the woman want? Oh, she probably wants to be free, to stay home, to do what she wants. Well, don't some of them want to work? Well, okay, that's the exception. But the majority will want that. And then they conduct the discussion. This is the assumption, and it's actually not completely unreasonable. There is evidence for it. But so you can take these tools and then again subject the subject of Islamic law and Islamic legal reasoning to these modern perspectives. Again, there are ways to do it and be excessive in doing this. So I try to go back to reasoning. I want to understand how the mind works, and I want to teach the students how the mind works. But when I apply it, for example, to modern national law, I know that the elements that enter into a decision in a Pakistani court, in an Egyptian court, in a Saudi court, are more than the academic considerations that my friends in sociology or history or feminist studies are interested in. There is a history. There's a specific history for every country. So people have to be aware of that. So in that section, let's take these 3 countries so we're not always floating like that. What's the basic story of modern Egyptian law as I tell it, as I understand it? I'd be very happy, of course, to be corrected or improve my understanding of this. But this was my first love. When I started in Egypt, I really wanted to figure out how to understand the Sharia clause that's in Article 2 in the 1971 Constitution. I have already kind of made some basic conclusions. Now, you learn in Egyptian law schools that religion, not Islam, religion is both of the following. It's something called masdar asli khas, meaning a source of law of general jurisdiction within a specific area, which is personal status. When you hear personal status or ahwal shakhsiyya, add to it in your mind endowments, which is actually a matter of property law, and gifts, which got regulated later in the Egyptian Civil Code, and inheritance. Now again, think about these three things that are not personal status. Personal status are the things that relate to how you define yourself. Religion is usually a very important part of that. Marriage is conducted based on that. The relationship between the man and a wife, whether you have multiple marriages or only one, right? So these are clear. Inheritance in Islamic law is connected to marriage. It's really, there are three causes for inheritance, and one of them is marriage, and one of them is nasab, which is essentially marriage, but the relationship that you have between you and your father, which comes from the marriage of your father to your mother. But you're not married to your father, but that nasab, that lineage essentially comes because of marriage. And then wala, which really is not useful in modern concepts. So there is a connection in the old system. In the modern system, no, these are property law matters. Distributing your inheritance doesn't have to follow from the same law that you apply when you talk about your divorce or child custody or things like that, or spouse support. So in Egyptian law, Islamic law is a basic source for Muslims, all Muslims in Egypt, when it comes to marriage and its consequences and these little matters of property law, because the Egyptian jurists, for example, when they talk about gifts, they say what people give gifts to religious organizations based on their religion. So it is kind of connected. So that's how they added it. That became enshrined in the Civil Code later in 1949. So religion is a source of law in that sort of generalized or glorified concept of personal status law. But it is also what they call masdar takmili, that it is a supplementary source of the law in everything. In everything, in theory, yes. In everything, but it is stated in the Civil Code only. It's not really, Islamic law should not be a general source of Egyptian law in criminal matters, for example. There is something of an animosity there that was established in the 19th century. Gradually, Egyptian jurists, from the beginning of the century, they adopted what they call the Napoleonic Code. When you read Egyptian legal literature and they say the old French law, they mean 1804 and after. After the modifications, by the 1860s, they established, for example, there's no corporal punishment. Okay, you can't punish a man or a woman, can't punish an adult by beating them, although that's acceptable in Islamic law. Beat the adulterer, beat the fornicator, and so on, right? The adulterer would get the death penalty, essentially, but also in a corporal punishment matter. That was dead. That was actually not even contested. By the 1880s, it was very obvious that all you can get the Sharia to be part of, which was still a moment of hesitation, by the way. We're talking about the 1880s. Hassan Fakhri Pasha, for example, at the time the Minister of Justice, December 7th, 1882. This is a moment after Egypt had the mixed courts. The mixed courts were an institution that was designed to help foreign citizens and deal with foreign interests. Egypt had about only 1% foreigners at the time, Belgians and French and so on. But they wouldn't trust the existing legal system, so they built the course. It was Nobar Pasha at the time, an Armenian Egyptian guy, very nationalistic, who came up with the idea in the 1870s, 1874. It started in 1875. It started to function after that. It employed a lot of lawyers, foreign lawyers, and judges, including an American judge by the name Brinton, who wrote the classic text in English about the mixed courts. So after the mixed courts, there was a moment of pause. Should we build national courts? Hassan Fakhri Pasha, on that date in December, he says, well, yeah, we should. And we should have the national courts operate, for now, by the same laws that the mixed courts use, but we need to modify these. It seemed that the two options they had, either you use the same law that the mixed courts had, but why have the national courts then? If you're going to use that law that the mixed courts used, you don't need the national courts. But if you're going to make a new law, that will take a long time. But he was interested in this modification, not just him. Most of the members of the cabinet at the time were saying that. And that was after the British invasion, just a few months after. And they were wondering whether he could codify the Sharia personal status law. That task went to Muhammad Atif Ahmad. He did the work, but nobody really was interested in adopting it as a code immediately, so they still went back to the madhabs and the old texts. But without telling the long and very boring story here, we end up with a very important understanding in these discussions that criminal law, Islamic criminal law, will never come back. There's just no way. The only way you can punish somebody, the civilized punishments are only two in kind: imprisonment and fine. I can take your liberty, I can take your money. And I can still take your life. Yes, the execution was always an important thing, but it needs a certain reason, right? And taking one's life somehow is not corporal punishment, okay? But it is really beating that is in question there. It was taken out of the question. The only beating you could do in Egyptian law in the 19th century that's legal is in the youth imprisonment cases. So you can beat, but you can beat only boys, not girls. You can beat a boy all the way until age 12. That would be legal. But you can't beat a girl at any age. That could not be the punishment. And after 12, no, there's no beating for adults. Now, did that happen in prisons? You bet it happened, but it's not punishment, right? Like it happens in America too. It's not supposed to happen. So when I look at the Egyptian system, there's no question that there is a lot of evolution. Actually, there are better historians than me who look into the 19th century and seem to uncover things all the time and surprise me all the time. So what's my task? What can I say there? I wanted to stick to something I thought I concluded and understood a while back. Islamic law can still enter into future Egyptian law by the same process that it has assumed for the last 70 or 80 years since Senhuri Pasha drafted the civil code, which is this. You have two kinds of elites, legal elites. Both of them understand modern law. Both of them study modern law. Some have Western education, some have a local education that's based on the Western principles. But in one kind of legal elites, people know something about Islamic law and are interested in the old text. Sometimes they understand it differently from the way it was understood by the madhabs. This is how I defined the crisis yesterday, right? You don't have that monopoly of how to understand the old text that was available when the madhabs were strong. You can also do what they call talfiq, which is picking and choosing, or forum shopping, for a reason, for a new reason. So there is certainly a new kind of jurisprudence that's emanating from dealing with these old texts. But that's how it enters. That's how Islamic law enters into modern Egypt. And it keeps entering. That is, the story is not over yet. You can still introduce new institutions based on Islamic law by this process. And I said competition between the two kinds of elites, but it could also be a process of negotiation. The story actually has a lot of interesting wrinkles, but I'm worried that if I keep talking, it'll be just Egypt tonight. So I'll say one quick thing and move to say something about Pakistan, something about Saudi Arabia. Since the 1971 Constitution, President Sadat had been interested in exploring what does that mean. He built committees within what they call the People's House, essentially the parliament, which started to be very active in the late 70s and even especially in the 80s under President Mubarak after Sadat was assassinated. And it just became more and more important, more and more powerful. This is a pattern, and you will realize the moment we raise a question of what does the Sharia say about this, there is a new possibility. There is a new way to hybridize from the old laws and sometimes explain the new laws by old ways, or sometimes change even the modern laws, make it something different because of the acquaintance with the Sharia. That pattern, I discovered later, actually applied in other countries too. In Pakistan, the introduction of Islamic law seemed to be a very abrupt event that happened because a general decided, that is, they all have decided, we will import laws from Islamic law, including criminal law, the taboo that the Egyptians wouldn't have. But what did he do? He introduced, the more important thing, of course, in Pakistan is that they have an institutional aspect to this. There is now what is called the federal Sharia courts. Pakistan is a federation. There is Islamabad, which is the capital, but there are also 4 provinces. So think of it as 5 pieces. And on top of each one of these pieces, there is a high court, an appellate court essentially, that used to have a Sharia bench, but now the Sharia bench is independent, is an independent court. It's called the federal Sharia court. And even the Supreme Court, Pakistan Supreme Court, which is on top of all that, has a Sharia bench. And they keep discovering all these moments of conflict because there are laws that could emanate from places like Punjab, and then they have implications nationally. It's not a real federation, it's not a total federation, right? So one thing you could do, because this is in English and it's online, read the annual reports of the Pakistan Supreme Courts. The decisions are actually brief, and sometimes it's irritating because they don't have enough information there. Every decision is about 2 pages. But you get an idea of what they're conflicted about and how they even look at Islamic law, Muhammadan law. You see these secular Pakistani judges, and they spell Muhammadan also the way the Orientalists used to spell it. Mahometan, I think it's Mahomeatean, and it's just funny. But and sometimes they look, it's a very foreign law to them, right? Their education doesn't allow them to even get into the primary sources. But in any case, there are federal Sharia courts, and they have their judges, and they know what they're doing. Siyasa is still part of this picture. Let me give you a case to see. So in say, qisas matters. Qisas is the killer is to be killed. Who decides that? In a modern state, the state decides. There's actually only one way to kill a killer. It has to be a prosecutor who represents the public interest and says we're going to not retaliate, but we're going to apply the punishment of execution to that killer because it's in the public's interest. No, that's not how it works in Pakistan. The family gets to say whether they want to kill the killer or not, because that's the way it was. There is a study, also in English, you'll find the following. There's a scholar named Tahir Wasti who did his work at SOAS in London, and his book got published by Brill in 2009. And he takes a very critical stance. He's very unhappy. He calls this a privatization of criminal law, right? Because the family gets a say. So, and in one case, but it's actually not a very good description because it's not fully privatized. In one case, Abdul Ghafoor versus Pakistan was a big case. 2000 decided. There was a policeman who was killed. And his family neither wanted retaliation nor wanted the blood money. So essentially they'd let the murderer go free. Okay, this is where Islamic law works. But it stops there. Because the state wondered, okay, the victim here was a police officer. Can you just allow a random person to kill a police officer and just walk out like that? Yes, maybe the Sharia would allow this family to say, we're not interested in killing this guy. We're not interested in blood money. But this is a political matter now. So essentially by siyasa, according to the old standards, they give the guy 3 years. And Tahir Wasti is very critical of this because he says, well, look, they're not consistent because they really introduce Islamic law to a point. But this is exactly the point. In all of these systems, it's hybridized like that. You will meet that even in Saudi Arabia. That was, of course, my biggest surprise because I had assumed that modernized, reformed Hanbali law that the Saudi court started to consider in the 1920s would look now something, recognizable to me. But the Ministry of Justice started to publish court decisions. There's about 10,000 pages actually on their website, 30 volumes of decisions. Their summaries are better, actually, but they don't have the names of the people too. But you get tons of cases, and for the people who read Arabic. I don't want to talk about, actually, let me not talk about the cases, but let me point to something in the introduction by the chief of the Supreme Judicial Council there, Sheikh Muhammad Karim Al-Aisi. And he talks about precedent. Now, there is a question that the ministry asks itself, why publish court decisions? Why are we publishing decisions by previous judges, and for whom? Are they for the judges, So now Saudi judges have to study that in addition to Islamic law or in addition to other. They keep also producing codes, right? The Saudis are into codifying and adding codes. In criminal law, it used to be just the old texts. And now they have the codes. They even have in criminal procedure. And they're based definitely on the old systems. But the system itself ran into a lot of hybridity recently because of WTO cases, the World Trade Organization, because of some human rights cases that became very political and got decided administratively. But it had that potential. I mean, I don't want to say that this is something they discovered in the 1970s or 80s. It had that potential from the beginning because the system is built on the idea that Sharia and Siyasa are the sort of the reign of the day, the system that they're going. So, for example, actually one of my advisors, Frank Vogel, whom I respect a lot, when he talks about legal chaos, I think he's also exaggerating. He's overemphasizing, mostly from high-profile cases, what it looks like some small-level judges can overturn an agreement that's by the government. Well, most of that goes up and gets corrected because the system has to find a point of equilibrium. But let me just say something about precedent, and then maybe I should shut up and we'll take questions. So does Saudi law now respect precedent? Where does it come from anyway? Neither the Latin schools, the codification schools, the European schools, nor Islamic law, nor Chinese law. I mean, it's just only the common law tradition that has this precedent. And why, by the way, do you know that? Because in 12th century England, it was a mess. It would be impossible to conduct any transaction that allows people to live on the island as one place. It was one of the Henrys, maybe Henry II or something, and he had these traveling judges. They'd go around in the provinces and make sure at least that every decision that's made by a court will be binding to the same court. So you don't keep deciding, similar cases differently. And then that became a doctrine, it became something they cherished. And by the way, it's a disaster now for American courts because they don't want to follow precedent a lot. I mean, they want to distinguish cases. You know what distinguishing cases is? To look at the precedent and say the new is different. The new one is different in the following respect. It's a practice that American courts have had now for more than 100 years. So you study and also in the law texts, you can read, this is what they decided in 1924. The next one, 1953, was distinguished based on the grounds X, Y, Z. So, no, there is no doctrine of precedent, he says. We can't bind judges to early ijtihads, but these new judges should also learn that you can't say that I'm not interested in the old decisions because al-ijtihad la yunqad bil-ijtihad. This is a principle, this is a legal maxim, you find it in qawaid books. And what does it mean? Al-ijtihad, meaning an independent jurist's independent reasoning in a given case, should not be a way to repeal another mujtahid's view. But this is a very specific situation there. I mean, the way medieval jurists explain this principle is like this. If there is a case between me and Suhaira, we're adversaries in a case, and it goes to a Hanafi judge, and the Hanafi judge judges it based on Hanafi doctrine, then somehow the adversaries, decide to go to a second court. In some cases, of course, that would happen in Egypt in the 13th century when they had the different courts. Maybe we change the madhab, and we decide to go with the same case to a Shafi'i judge. If the Shafi'i judge repeals the Hanafi decision simply based on the doctrine, that he judged it based on Shafi'i law, therefore it changed the law in this particular case, they say if this case should go to a Maliki judge, he should go back to the Hanafi decision, because there was no reasonable way for the Shafi'i judge to just judge the judge. The Shafi'i judge can't judge the Hanafi judge. And it would go the other way around. They say actually that would go infinitely. If we were to keep considering, so imagine the appellate hierarchy for them is very counterintuitive. The appellate hierarchy is meaningful to us. Why? Because the one who made the decision to appoint an appellate court on top of the first instance is not a judge, and it's not based on ijtihad, it's just a political decision. So that solves it right there. But if it is based on qualifications, you can't just count years and say this is an old judge, or now it's based on, this guy is a genius, so put him on the appellate court, right? It happens. So this is an example of how the chief of the Judicial Council, Supreme Judicial Council, is struggling to explain whether they care about stare decisis or they don't in Saudi law. And he keeps making comparisons with Latin systems and other systems. The point is, Saudi law actually ended up with something like a mixed court system because of the agreements that the Saudi government made, which penetrated many aspects of Saudi society. So with all the hesitation that I could have about this, I can see very much the same process. That most of these countries end up hitting a madhab kind of thing. There's a Saudi madhab and an Egyptian madhab and a Pakistani madhab, which might begin by modifying an old madhab. Pakistanis are explicit that they care more about Hanafi law. Saudis are explicit they care about Hanbali law, although they're much more comparative than people give them credit for. And the Egyptians, they had a lot of commercial Ottoman law, by the way, in the 19th century, even as they were rejecting most of the old Ottoman laws, which were Hanafi, right? Ottoman commercial laws, but they evolved also to include many aspects of the other systems. Senhuri teaches essentially scholars of law that the point is the argument, is not the madhab, right? You look at your society, you look at how you understand Egyptian society, and you find a good explanation from the previous institutions that explain why this society is like this. Because part of why we are the way we are is that this is the way we've been. Right? Not everything changes just by the passage of time. So this is where I leave it. There is no single story, of course, that you can tell. And I apologize if these comparisons seem to be offensive to some people. I have a student from Turkey who never allows me to talk about Turkey and compare it to any other country because Turkey is just incomparable. It doesn't compare to any country, which you understand. I think I used to be there, when I lived in Egypt. But after a while, you kind of get tired of that. Well, nothing compares to it, but Cairo doesn't compare to Alexandria. And then you have no textbook. You can't tell students anything. Well, anyway, so I'd like to stop here and just make sure that you got something out of this and go back to basic points by taking some questions.